Shri Arjun Ram Meghwal, Honorable Attorney General Shri R. Venkatramani, keynote speakers Shri Fali Nariman, retired Chief Justice Deepak Mishra, Shri Gurumurthy, and Shri Ram Sham Diwan, ladies and gentlemen. It is with immense pride that I welcome you all to the fourth edition, which is the centenary edition, of the Ram Jethmalani Memorial Lecture. The lecture series was first launched in 2020, and in virtue of COVID and its aftermath, it was conducted virtually. This is the first physical event which is also being broadcast virtually, and I pray that this hybrid format persists for all times to come. It is a measure of the success and popularity of the lecture series that in addition to Republic TV and NewsX, who broadcast this event last year, this year the series is being covered live by a large number of prominent sections of the print, electronic, and digital media live. I extend my heartfelt gratitude to all of them. This year, we are honored to have as chief guest the present Chief Justice of India, Honorable Shri Dr. His concurrence to preside as chief guest at today's event would have particularly warmed my father's heart, not only because of the eminence of his office and his erudition as a jurist, but more so because post-partition, after he joined the bar, Dr. Chandachud's parents were amongst the earliest and closest friends of my parents, a friendship that endured till the very end. I warmly welcome as well the Honorable Law Minister, Shri Arjun Ram Meghwal, and the Honorable Attorney General, Shri R. Venkatramani, for taking time out of their busy schedules and agreeing to participate as guests of honor at this event. I also welcome and thank profusely every one of our four keynote speakers on the topic of today's discussion. The panel of keynote speakers has been very carefully curated. All of them, through their actions, speeches, judgments, arguments, have been passionate crusaders for our constitutional rights and have done their utmost to ensure that the flame of liberty in this country burns brightly. Their expertise on the topic of today's discussion is renowned. While my friend, old friend, or friend of old, I would say, Mr. Gurumurthy, is not a jurist. He was part of what in 1975 was called the Indian Express Group, which under the legendary newspaper baron, the late Ramnath Goenka, and my late father, fearlessly battled the declaration of emergency. He has lived and suffered the subversion of Article 19, and his experience has given him a deep insight into the Constitution and the pros and cons of the basic structure doctrine in particular. Finally, a word about today's topic of discussion. Throughout his career, both legal and political, my late father had many glorious moments, and of course, to be objective, some eminently forgettable ones as well. But all things considered, if I had to pick his finest hour, his absolutely best hour, it would be the relentless and magnificent battle he fought both inside and outside the courts at great personal risk during the emergency. Liberty was his compelling and enduring passion, and he was eternally vigilant about it, about protecting it. Today's topic is designed to determine how future generations can best secure their freedoms. The basic structure doctrine stares us in the face. It once failed us. This judicially fashioned core feature of our Constitution is too layman, esoteric, and enigmatic. I hope that today's discussion enlightens us about the meaning, scope, limits, and most of all, the viability of the doctrine of the basic features as the anchor of our fundamental rights. Thank you, ladies and gentlemen.
Ladies and gentlemen, the Honorable Chief Justice of India, Justice Dr. D.Y. Chandrachud.
The family of Mr. Ram Jethmalani, who is assembled here from near and far, Mr. Arjun Ram Meghwal, the Union Minister for Law and Justice, Mr. R. Venkatramani, the Attorney General for India, a very distinguished Chief Justice, Justice Deepak Mishra, Mr. Fali Nariman, Mr. Sham Diwan, Mr. S. Gurumurthy, members of the bar, and everyone present here. I'm quite overwhelmed, honestly, to be speaking about Ram Jethmalani, whose legacy continues to resonate in the hearts and minds of people across India. Yesterday was his 100th birth anniversary. It is not every day of our lives that we get the opportunity to celebrate the legacy of such great human beings. And honestly, I thought I should say a few words about him. Because for the younger generation, many of whom have not witnessed the years that we have to ask ourselves, how do you clone a Ram Jethmalani? And can we really clone Ram Jethmalani? Possibly no, because to clone Ram Jethmalani, we'll have to clone the social and the historic and the political times in which he grew and flourished and evolved as a human being. He donned many robes. He was India's top criminal lawyer, unquestionably so. He was an acclaimed parliamentarian, elected as a member of the Lok Sabha twice and of the Rajya Sabha once. Ram's legacy endures not only because of his unparalleled mastery over the law, but also due to his relentless pursuit for justice through legal and constitutional means. He lived in times when one could be despondent about the way in which things were turning out after independence. But he never gave up his pursuit, his faith, his belief in the Constitution, in the law, as a means of bringing out orderly change. He was, in that sense, a luminary who left a profound and lasting contribution to the rule of law. Ram Jethmalani's first case was before the Sindh High Court at a young age of 17. The enrollment rule prescribed a minimum age of 21 years, which prevented Ram Jethmalani from starting his legal career at the age of 17. Ram argued his own case before the Chief Justice of the Sindh High Court when he was a student of law, challenging the minimum criterion prescribed by the rule. He passionately argued before Sir Godfrey Davis that his parents would not have permitted him to study law if they knew that he would not be able to support the family for 4 years after graduating, in a sense. It was an argument of legitimate expectations, as we would have perhaps learned to call it several years thereafter. Ram clothed this argument of legitimate expectation with an emotional undertone, and it worked in his favor. Sir Godfrey, who was swayed by Jethmalani's persuasive skills, asked the Bar Council to amend the rules to introduce an exception. The colonial masters in those days didn't feel constrained by what we feel, namely the limitations on our jurisdiction to issue a mandamus to the legislature or to a subordinate to amend the law. It was right at that time, at a young age of 17, that both Ram and those around him realized that he was going to be a formidable force in the legal fraternity and who had the ability to take the courts by a storm. This early display of determination and commitment set the stage for a lifelong pursuit of justice. He came to Bombay, as it was then called, with all but rupees 10. As a refugee, he understood the plight of those at the fringes especially the partition refugees. Just 3 years into his practice at Bombay, Ram Jethmalani made his first impression as a constitutional lawyer. He argued a challenge in the Bombay High Court to the Bombay Refugee Act of 1947, which granted extensive powers to the state government to confine refugees. Ram deemed it an affront to their dignity and passionately argued against its constitutionality. It was the first case that he argued after he enrolled as an advocate and went on to win it. Despite the recent adoption of the Constitution and a lack of guiding case precedent, he successfully argued that the legislature did not have the competence to enact such an excessive law. And he sowed the seeds of proportionality in his argument. He went on to appear before the Supreme Court in 1957, just 10 years after he started his practice in Mumbai. Even in his initial years of practice, he carved a reputation for himself as a brilliant criminal lawyer. In 1959, Ram was involved in the prosecution of K.M. Nanavati, Commander K.M. Nanavati. Commander Nanavati was an officer in the Indian Navy, handsome at that, who had settled down in Bombay with his English-born wife and their children. With Nanavati being away from home on long assignments at sea, Sylvia found companionship with Nanavati's friend Prem Ahuja. Sylvia confessed about her affair to Nanavati on his return from his assignment. Enraged by the confession, Nanavati went to the naval base to collect his pistol and then went to confront Ahuja. According to Nanavati's account, he had asked if Ahuja would marry Sylvia and accept their children. On hearing a negative response, he fired 3 bullets and not unexpectedly, Ahuja just dropped dead. The case was tried by the jury, the last case that we ever tried by a jury in India. The issue before the jury was whether Nanavati shot the victim in the heat of the moment or whether it was premeditated murder. Ram was hired as a watching counsel by the sister of the victim. His role was to protect the victim and help with the prosecution strategy. There was the great Chari who was appearing in that case. The public prosecutor followed the line of questioning developed by Ram, and theatrical it was. He asked the surgeon on the stand why the victim would start the alleged fight without his glasses on, and how the 2 protagonists could have got into such a scuffle that the gun would go off accidentally with a towel wrapped around the waist of Prem Ahuja undisturbed. The case was sensationalized, and the jury was overawed with emotions for Nanavati and handed him an acquittal. However, if the judge wanted to send the case to the High Court for reconsideration, they had to prove that the jury was under wrong instructions. A decision of the jury could be overturned on very limited grounds. It was Ram Jethmalani who wrote the brief for the prosecution lawyer, then Mr. Y.V. Chandrachud, pointing out 8 instances of jury misdirection. The argument of jury misdirection was accepted. When the case was heard by the High Court, it found merit in the arguments of the prosecution and convicted Nanavati. But there's a story, there's a sting in the tail, which Ram himself told me about. He said when the case opened, the entire court was hostile to the government pleader, namely Justice Chandrachud, who was then arguing the case. This was on the last day after the conviction had been rendered. Justice Shelat turned to the government pleader and said, Mr. Chandrachud, so are you pressing for death? Virtually indicating that if you argue for death, this was a case for the imposition of the death penalty. And we didn't have Bachchan Singh in those days, mind you. And the public prosecutor got up and said, my lords, I've got the conviction, but this is not a case for the award of the death penalty. And eventually, he was sentenced to imprisonment for life. The appeal against the conviction was also dismissed by the Supreme Court, but he got a pardon thereafter. There really began the friendship between my own parents and Ram and Ratna, which continued almost to the last day of their lives. Ram had the wit and vigor to work within the minute gaps and the gray areas of law. That is what set him apart from the rest of them. As a criminal lawyer, he was known for his art of cross examination, bravado, and wit. He approached his cases with an investigative lens, an important craft for every criminal lawyer. He would ask for plausible explanations and give an astute psychological analysis of what a person normally would or would not do. Ram had that innate ability in him, which only the best of the criminal lawyers have, of recreating a crime scene. In 1988, he was appointed as amicus curiae to defend the person accused of assassinating Prime Minister Indira Gandhi. The trial court had convicted 3 persons for the assassination and sentenced them to death. The High Court of Delhi confirmed the death sentence. At the Supreme Court, as amicus curiae, persuaded by Ram Jethmalani's argument, a 3-judge bench unanimously not only set aside the death penalty, but also reversed the conviction of one of the accused, namely Balbir Singh. He would call this case one of his best forensic successes. The prosecution evidence relied upon a piece of paper supposedly found in the pocket of the accused with cryptic dates and names. Ram argued on the obvious foolishness of any person in carrying incriminating evidence after a month of the crime when public opinion was so heavily against the perpetrators. Ram gave it his all to prevent the execution of the other 2 accused persons as well. On the counsel of Jethmalani, the accused had petitioned the president under Article 72 of the Constitution to grant pardon, which was rejected. News broke out that the 2 men convicted of assassinating Indira Gandhi were to be hanged at 8 p.m. the next day. However, the hanging was stayed by the Supreme Court just 14 hours before the planned execution, because Jethmalani had raised a constitutional question over the president's refusal to grant him a hearing. He argued that the pardoning power of the president cannot be exercised arbitrarily and that there must be guidelines for the exercise of this power. Because, as he remarked, secret guidelines, he said, are no guidelines. Though he was able to secure a short-term stay of the execution, he was unable to get it set aside. A month later, both the accused were hanged. But Ram's contribution should not be downplayed. He raised seminal constitutional questions in the course of the hearing, which went on to change the legal landscape on the death penalty. He couldn't protect his 2 clients from execution, but he protected the Constitution and the way it has evolved and as we know it today. I would even consider this case as one of the cases which sparked the extensive debate on death sentence in India. Ram Jethmalani was not only a formidable advocate, but also passionate teacher. He started teaching at the Government Law College in Mumbai in 1953, an accomplishment that was no small feat for a person with no prior connections in the city. His eloquence, meticulous preparation, and deep knowledge made him one of the most sought-after teachers. He went on to play a pivotal role in the setting up of the National Law School of India University at Bangalore. Ram was beautifully networked. Whom did he not know in the political or legal scene? But he used his network for social purpose. He was a great friend of Ramakrishna Hegde, the Chief Minister of Karnataka, but he persuaded Hegde to give land for the Bar Council of India's National Law School of India University. In fact, he also went on to teach a course on the law of evidence at NLSIU for a term. His contributions led to the formulation of the 5-year integrated law program, an independent entrance examination for law schools, academic autonomy, and better quality education for students with a holistic curriculum. Ram Jethmalani would say that he would like to be remembered as a good teacher who could make a difference to the lives of the young. And difference he made. His teachings inside and outside classrooms, both at National Law School and at Symbiosis in Pune, which he was deeply fond of, continue to guide his students, his juniors, and even the judges like me, who had the pleasure of hearing his succinct legal arguments. Ram, in that sense, democratized access to the legal profession. By setting up these law schools, legal education ceased to be the prerogative of those who are socially advanced or economically resourced. Legal education opened up for people without background, without family connections, without social capital, without cultural capital. Ram's unflinching sense of courage must also be remembered and celebrated. When the emergency was imposed in the 1970s, and when the civil liberties of persons were put on a hold, speech was censured, and arrest warrants were issued carelessly and callously against political opponents. Ashok Mahadevan, a young journalist of 26 years old, protested against the suppression of speech by publishing a 22-word obituary in the Times of India. One thing which I learned as a child was to devour the newspapers. And I still remember this obituary, which I must share with particularly the younger people here in the audience. And the obituary on the 26th of June, 1975 read as follows. Hear it carefully. O apostrophe crazy, DEM, beloved husband of T. Ruth, loving father of L.I. Bertie, brother of faith, hope, and Justicia, expired on June 26. The young journalist, with the use of smart wordplay, protested against the emergency. The obituary actually meant that democracy, the loving husband of truth, loving father of liberty, brother of faith, hope, and justice, expired on June 26. That is the day the emergency was declared. The legal community on many fronts, both inside and outside the courts, led the struggle to restore the rule of law. And Ram was at the forefront. He was the chairperson of the Bar Council of India during the emergency and was very vocal about his opposition to the emergency. In 1976, he spoke fervently against the imposition of the emergency and the curtailment of liberties while he had gone to attend the All Kerala Lawyers Conference in Palghat. Even before he could travel back to Mumbai, an arrest warrant was issued against him under the provisions of the Maintenance of Internal Security Act. No less than 300 lawyers, led by Nani Palkhiwala, went to the Bombay High Court to secure a stay of the arrest warrant. But the stay was good only till the Supreme Court pronounced its verdict in ADM Jabalpur versus Shivkan Shukla. While arguing the ADM Jabalpur case, Ram memorably reminded the judges that erosion of civil liberties spares no one in its wrath, not even the courts. Ram began his arguments before the Supreme Court by saying, "My lords," he said, "you will not be impressed by the fact that I am appearing for one detenue. Now I am going to tell you that I am appearing for all 5 of you." Like the outcome of this case, he witnessed many firsts and the lasts in the legal landscape, but his heart lay in strengthening democratic institutions. He never despaired by outcomes which were contrary to what he argued as a stated legal position. In that sense, he didn't have the ego of a person who believes he's morally right in everything that he argues, because he knew that he was arguing for a perspective which he believed in. During his legal career, which spanned over decades, Ram argued as a defense lawyer in a lot of high-profile cases, such as the Harshad Mehta market scams case, which, by the way, was fortunately the case which led the lawyers' fees to go out of the roof. The Hawala scam, the accused in the Jessica Lal murder case. When he was asked if he appeared for a lot of high-profile cases because it paid him well, he replied, "Of course, naturally," he said. He also went on to say that a lawyer who refuses to defend a person on the ground that people believe him to be guilty is himself guilty of professional misconduct. But Ram also understood that access to justice would be an illusion if lawyers charge exorbitant professional fees or appearances. He recognized the deep inequalities which plagued the society and was deeply concerned about the injustices meted out to the common citizen. By some estimates, he charged only 10% of his clients, and 90% of the cases were handled by him pro bono. I've actually witnessed him in the bar library of the Supreme Court Bar Association, quoting a fee virtually at the back of his hat or the top of his hat and asking for a fee of the unstatable. He also recognized that institutional reforms are required to enhance the quality of justice and access to justice. He once said that only perceptive practitioners sitting in court notice the frequent miscarriage of justice. Correction does not require legislation. Setting up traditions binding on the Chief Justice of the court is enough. So I thought I'd end the first part of my presentation by reminding myself that you do not require a change in legislation. Setting up traditions binding on the Chief Justice of the court is enough. Ram was an amazing mentor. I'll just give you two little examples and I'll then go to the more formal part, and I hope not to bore you beyond that. We were doing a high-profile case and we were appearing for the chairman and managing director of a not-to-be-mentioned corporate group in India. In the Bombay High Court, an excise circular was placed before the court, and it so happened that the circular was fabricated. The judge in the Bombay High Court decided to initiate proceedings under Section 195 and 340 of the CRPC. And we came in appeal to the Supreme Court. And we were against one of the most hostile benches that you could imagine. And it made it worse for us because we thought that both the judges had a slightly pro-revenue stance in their ideology. The first part of the session, the morning session, Ram was subject to a hostile bench. We went back to his chamber for lunch, and we were extremely worried about what the outcome was going to be. So we asked Ram, well, what are we going to do after lunch? So he looked at me and said, for starters, we need to get some chicken patties from Wenger's. So order we did for some chicken patties from Wenger's. I don't know whether it was the patties or what happened, but after lunch, it was just sheer brilliance. Brilliance personified. In about 20 minutes, we had the judges completely turned. One of the most hostile benches came and said, well, we are allowing the appeal. As Ram evolved in life, many of his lesser known clients had to go to the lesser known lawyers because he was no longer fit enough to appear for them. And that's how people like me who were fledglings at the bar picked up the work. He introduced me to the Indian Express work. There were remnants of the work which had remained, the Customs Act cases of the emergency, which were still lingering on in the 1980s. And that got me an opportunity to go to Express Towers with Ram's juniors and to prepare pleadings. Criminal appeals. It was a sheer joy to sit with him. To sit with him even while drafting a specially petition. I remember a case where there were about 14 accused. And he gave me a brief sitting of about 10 minutes to explain to me how a criminal appeal should be drafted. How you must analyze the role of every accused. Who were the eyewitnesses? What was the specific act, the overt act which was attributed to the accused? The topic of the day, of course, which Mr. Mahesh Jethmalani has thought everybody should open up with, is about the basic structure doctrine. Much as I admire Mr. Ram Jethmalani, one thing I wouldn't like to share with him is his ability to court controversy. So I thought that if I have to do something about this doctrine, I should do it through my judgments and not in an off-the-court pronouncement. So I've taken Mahesh's permission to talk about something a little different. And that's just about 5 or 7 minutes. The Supreme Court, which all of you probably don't know about. And let me tell you a little bit about the Supreme Court you don't know about, because you read about the Supreme Court in the electronic media, social media, they're trolling us every day, the print media, and of course the law reports. But let me tell you about the court which I would like to tell you about. The COVID-19 pandemic had just started receding when I took over as Chief Justice of India. I was aware of the huge responsibility which I would be shouldering. The pendency rates had increased because of the pandemic. Most of us had lost somebody dear. The pandemic had not only brought the world to a standstill, but also left emotional scars from which we are yet to recover. While I knew that I had to prioritize speedy disposals, I also knew that I had to prioritize the mental health of lawyers and registry officials, by not pushing them to overwork themselves both physically and mentally. They are not poster persons of the justice delivery system, but they are certainly at the forefront, keeping the cart moving one day at a time. It is important that their efforts are recognized. My first goal as the Chief Justice of India has been to institutionalize the courts and move away from an ad hoc model of operation. Too often, the problems with our institutions are that every individual who comes into the institution lays down innovative ideas, only for those ideas to be forgotten after each of us passes on the baton to the next person. One of the important effects of institutionalizing courts is that it enhances transparency and accountability. While these are very important effects of institutionalization, we should also not forget the human side of the story. I have, in the course of my 10 months as the Chief Justice, realized that institutionalization, in addition to enhancing transparency, also humanizes the workspace. The staff are able to draw boundaries between work and home and increase their work efficiency. It has also positively changed things on those on the other side, that is the bar. We have implemented filing of cases in the electronic form, removal of defects, submission of urgent listings, and appearance slips, all through online portals in the Supreme Court. It's way more easier now to file pleadings than to live in the anxiety of standing in lines, waiting for a person to mark defects on the file and returning it to be filed afresh. Citizens can now also find out the status of their cases instead of having to rely on their advocates, who, because of their busy schedules, may not always relay the update. Of course, this is a change, and changes don't come easy, but it is a change worth making for enhancement of the justice delivery system. At this point, it is necessary to emphasize that when I speak about enhancement, I do not limit the reference to quality judgments. My focus is also on reducing barriers to accessing the courts, easing the process of filing and arguing before the court. My focus is on improving the gender ratio of lawyers. My focus is on ensuring that lawyers and litigants have facilities to comfortably rest while at court. It is only with such an holistic approach that the quality of justice delivery could be enhanced in every sense of the word. The Supreme Court is bursting at its seams. Our building was constructed in 1950, and we have moved the government with a blueprint of a new building to replace one of our older buildings, which were constructed in the late 1980s or 90s, and to have a modern Supreme Court building in the same complex with 27 courtrooms, bar association spaces for the women lawyers, for the Supreme Court Bar Association, for the advocates on record, and above all, for our litigants. One of the primary requirements for institutionalizing the court system is to identify the issues that hamper our efficiency and curating remedies to address such issues. An able team of judges, lawyers, and researchers working at the Center for Research and Planning are assisting the courts with this work. Their work is invaluable, particularly because of the lack of research and data on the functioning of courts in India. The Center for Research and Planning is now in the process of creating a system for managing and reducing the case pendency through a project called SC Judicare, which stands for Judicial Disposal through Case Management and Resource Efficiency. The project aims to increase efficiency through improved case classification, grouping, and tagging. Phase 1 of the project is underway, where we have collected data on pending dockets to frame guidelines. We have also prepared a roadmap for auditing criminal matters. Our aim is to integrate granular data with integrated case management information systems, identify infructuous matters, and devise strategic priorities at an institutional level. Let me also deal with one of the criticisms which I hear, and I look at criticisms in a very positive and optimistic perspective. Because if you look at criticism cynically, you can never improve your institution for the better. One of the criticisms which is expressed about the collegium is that we have no factual data to evaluate people who we are considering for appointment to the Supreme Court. I just wanted to share with you some of the steps which we have taken. It's still work in progress, but we are improving. I have a Center for Research and Planning. The Center for Research and Planning is headed by an officer from the Haryana Judicial Service with two very distinguished young scholars and a number of young people, interns, law researchers who come and work with us for 2 years. We have prepared a dossier. I shouldn't call it a dossier, but we have prepared a broad platform where we have assessed every one of the top 50 judges in the country who would be considered for appointment as judges of the Supreme Court. We have data on judgments. We have data on reportable judgments. We have data on the quality of judgments which judges are delivering. The idea is to make the process of recommending appointments to the Supreme Court more transparent. Not transparent in terms of sharing our discussions in the public realm. You can't obviously do that. But by laying down objective parameters for selection both to the high courts and to the Supreme Court. Yesterday, the Supreme Court got on board the National Judicial Data Grid, which would provide real-time tracking of disposal and pendency with a click. This will increase inter-court coordination of data and aid in conducting quality research. Disposal and pendency of the Supreme Court is now available case-wise, year-wise, stage-wise, and quorum-wise. This information will help the court to identify areas of concern to decrease pendency. Institutionalization requires policy solutions. Due to the lack of data, it has been painfully difficult to devise methods to reduce pendency. Now, we know according to the NJDG data, there are 62,946 pending civil cases and 17,555 pending criminal cases. We also know that 15,000 cases have not been registered as yet, which means that the lawyers have still to get these cases ready for hearing. So the actual pendency is in the vicinity of 65,000, with 15,000 cases not really in that stage of being pending judicial cases. We have had a disposal rate of 95.34% this year. Our court has disposed of 95% of the cases which have been instituted this year. This data will help me prioritize certain categories of matters, such as the oldest pending cases, for their able disposal, and would allow us to introspect our performance in terms of disposal throughout the year. Another significant step that we have taken is to make the Supreme Court and High Court judgments available through the eSCR portal. When I started litigating way back in the 80s in the Bombay High Court, we used to get the All India Reporter or the Supreme Court report volumes upon subscribing to their print editions. We would wait to see the latest development in law and would be so thrilled to find a senior's office or a court library with an up-to-date record. In our common law system, court precedents are a vital source of law. Now there are online databases available, and the printed AIR and SCC records have become decorative books in law chambers. However, many young lawyers and law students find it difficult to subscribe to online databases because of the high price. This creates a professional barrier for young graduates, particularly from those from marginalized communities, such as the scheduled castes and the scheduled tribes. But the difference between my days of legal practice and lawyers starting out today is that dissemination of information is no longer priced. What was once impossible is now a reality. More than 36,016 Supreme Court and 11.6 million High Court judgments are available on the eSCR portal and the free text search portal of the E-Committee of the Supreme Court. The portal allows free text search of judgments by providing a combination of various search options and keywords. The embedded filtering feature allows further filtering on available results. The eSCR project was devised with the aim of providing free access to judgments so that a person's financial standing or institutional affiliation does not unfairly restrict them. In that, we must think of Ram when he came back from Sindh, and not Ram as that very highly resourced, extremely brilliant lawyer at the top of the career. We cannot pretend that these issues do not exist. The eSCR portal is a challenge to the mindset that one requires financial standing to make quality arguments. I implore all the lawyers here to start using the search portal. If any of you have ideas to better the services provided by eSCR, kindly reach out to my office. We are now also moving to a paperless mode of pleadings and communication. Courtrooms of the Supreme Court are becoming tech friendly. In courtrooms 1 to 3 of the Supreme Court, the law books that once marked the perimeter of the room are replaced with e-libraries. Digital display systems have been installed for judges and advocates. In the constitutional bench hearing on the challenge to the abrogation of Article 370 that concluded recently, we saw a record of 47,835 pages of paper book, case documents, case law, compilations, and written submissions of the petitioners and respondents. All of them were scanned and digitized to allow a paperless bench and a largely paperless bar. I like to practice what I preach. In my office, all communications for approval with the registry, even internal notes take through the paperless mode, through e-office. When I took over as the Chief Justice, I realized the sheer frequency and volume of approval that is required for every decision taken by the court staff and the registry, including the flowers that are put in the foyer of the Supreme Court. Each time the staff would come to me with a stack of papers to peruse only for a signature, I took a call and asked the staff in the registry to send over e-documents, which are now e-signed by me. I'm not sure how Ram Jethmalani would have reacted to these reforms. But I thought I should mention this because I know that he is sitting up above the twinkling stars, he and Ratna, with my own parents, Yashwant and Prabha. True to his maverick pedigree, he would have given further suggestions for improving court's efficiency and reducing case backlog. He touched us with the genuine concern he shared for the systems he inhabited. A fitting tribute to a person like Ram is that we too continue to be concerned and be a part of change in the systems we inhabit. The way I see it, he was not just concerned about what he found, he was more interested in whether he left it better than he found it. It has been a great honor reminiscing the legacy of Ram Jethmalani, one of the greatest of our times. Thank you very much.
Thank you very much, sir, for your words of immense value. We are indebted to you for having been with us despite your incredibly demanding and tight schedule. Thank you very much, sir, for having been with us. As the Honorable Chief Justice takes leave, I request Mr. Mahesh Jethmalani to please escort him and see him off. Please be seated, ladies and gentlemen. We will continue with our program. I'd like to now introduce our guest of honor this evening, the Honorable Union Minister for Law and Justice, Shri Arjun Ram Meghwal. The Honorable Minister steers the ship on the side of the executive to ensure that democratic principles and the principle of law are upheld in consonance with our enshrined constitutional values and vision. He plays a pivotal role in shaping the legal landscape, ensuring that our nation's laws and justice system reflect the values and aspirations of our diverse society. May I invite the Honorable Union Minister for Law and Justice, Shri Arjun Ram Meghwal, to please deliver the keynote address.
राम जेठमलानी जी की याद में जो आज मेमोरियल लेक्चर रखा है, इसमें बहुत सी बातें हमारे चीफ जस्टिस ऑफ इंडिया जस्टिस ऑनरेबल डी.वाई. चंद्रचूड़ साहब ने बोली और मैंने भी सुनी, आप सब लोगों ने सुनी। उसमें कुछ चीजें जोड़ूंगा। मंच पर उपस्थित जस्टिस श्री दीपक मिश्रा जी, ऑनरेबल फॉर्मर चीफ जस्टिस ऑफ इंडिया, श्री आर वेंकटरमणी जी, अटॉर्नी जनरल ऑफ इंडिया, श्री एस नरीमन जी, एस गुरुमूर्ति जी, श्याम दीवान जी और महेश जेठमलानी जी। देखिए, मैं दो संस्मरण आपको सुनाता हूं। ऑनरेबल चीफ जस्टिस ऑफ इंडिया चले गए, मुझे लगता है कि ये 2 बार लोकसभा में रहे और 2 बार ही राज्यसभा में रहे, जहां तक मुझे ध्यान है। मुझे महेश जी 2 बार रहे राज्यसभा में, 2 बार रहे राज्यसभा में, 2 बार रहे ना राम जेठमलानी जी?
कम से कम 4 बार सर।
हाँ, तो ऐसे वो कमी हो गई, वो 1 बार का बहुत। कितनी बार रहे? 4 बार।
4 बार
लोकसभा कितनी बार रहे?
2 बार।
2 बार। राज्यसभा तो बहुत रहे, इसका मतलब। नहीं, ठीक है, ठीक है। मैं एक किस्सा सुनाता हूँ 2013 का आपको। आप तो थे नहीं महेश जी शायद घर पे। वो राजस्थान से राज्यसभा के मेंबर थे, आपको अगर गलत नहीं हो तो हम एक ऐसे ही मेमोरियल लेक्चर मेरे बीकानेर में करने का विचार आया और मैं गया उनके पास। मैंने कहा आपको बीकानेर ले जाना है, क्योंकि वो कुछ एक कमेटी थी, उसमें हमारे साथ 1-2 बार आए थे, तो उनको लगा ये ठीक है, ऐसा लगा उनको कि आदमी ठीक है, चलिए। तो मैंने कहा बीकानेर चलना है। तो उन्होंने कहा आपको 2 पहले कंडीशन पूरी करनी पड़ेगी। मैंने कहा क्या साहब? मैं घर गया था, शाम का टाइम था। बोला पहले तो आपको मेरे साथ बैडमिंटन खेलना पड़ेगा। तो मैंने कहा बैडमिंटन आप इस उम्र में खेलते हो क्या? तो बोला उम्र कोई बाधा बनती है क्या? बैडमिंटन खेलेंगे। तो मैं इसी ड्रेस में रहता हूं, आमतौर पे मैं इसी ड्रेस में था। मेरे को कहा खेल लोगे क्या? मैंने कहा मैं खेल लूंगा, मैं भी बैडमिंटन का तो शौकीन हूँ, खिलाड़ी हूँ। तो हमने खेला, 4 प्लेयर थे हमारे। लेकिन उस उम्र में भी इतनी शानदार उन्होंने बैडमिंटन का खेल खेला, जवान भी नहीं खेल सकता। इसके लिए उनको धन्यवाद देना चाहिए, बहुत अच्छा अपना। बट दूसरा मैंने नहीं किया। दूसरी उन्होंने कहा यू हैव टू सिट विथ मी फॉर ए कंपनी। आप लोग समझ गए ना? हाँ, समझ ले तो जोरदार हंस सकते हो। मैंने कहा मैं, बोला ऐसा कैसे हो सकता है, ऐसा संभव ही नहीं है। मैंने कहा इसमें मैं आपके साथ बैठ जाऊंगा, अगर कुछ चीज खाने की आएगी तो खाऊंगा। लेकिन ये दोनों एक्सपीरियंस में करीब घंटा 1.5 घंटा रहा उनके घर, दोनों बहुत शानदार एक्सपीरियंस। और मुझे लगा कि इतने शानदार इंसान, जानदार और शानदार, नॉलेज का तो कोई शान ही नहीं था उनका, वो तो एक अलग विषय है। लेकिन बहुत ही शानदार और जानदार इंसान, उनके लिए आपने लेक्चर्स, मेमोरियल लेक्चर रखा। बेसिक स्ट्रक्चर के बारे में बाकी लोग बताएंगे, अभी मैंने देखा वो ऑनरेबल चीफ जस्टिस ऑफ इंडिया बताएंगे, लेकिन उन्होंने बाकियों के लिए छोड़ा, मुझे ऐसा लगता है। लेकिन मेरे को उन्होंने कहा कि श्याम का मेरा बेसिक स्ट्रक्चर है खेलना, दूसरा बेसिक स्ट्रक्चर है बैठना। बहुत शानदार इंसान। मेरे को अभी नानावटी केस के बारे में, जब हम पढ़ते थे कॉलेज में, लॉ का स्टूडेंट होने के नाते, ये आज उन्होंने जो ऑनरेबल चीफ जस्टिस ऑफ इंडिया साहब ने समझाया केस, उस समय भी समझाते थे, क्या शानदार केस में। लेकिन कहां सिंध से प्रैक्टिस शुरू की, नानावटी केस में भी फेमस हुए, इमरजेंसी में भी फेमस हुए, श्री राम मंदिर वाले मामले में भी फेमस हुए, अडवाणी जी के केस में भी फेमस हुए, मोदी जी के केस में भी फेमस हुए, लालू जी के केस में भी फेमस हुए। कौन सा केस है तो उन्होंने छोड़ा, और हर केस में फेमस हुए। जबरदस्त उन्होंने इस देश को दिशा दिखाई। और मुझे तो गर्व ये होता है महेश जी, कि जिस जगह मैं आज बैठता हूं, उस कुर्सी पे भी राम जेठमलानी बैठे हुए थे, लॉ मिनिस्टर भी थे वो। तो ये मेरे लिए तो बहुत गर्व की बात है। बलबीर जी पुन साहब आए थे, तो मैं ये कहने वाला था कि आपका आर्टिकल एक मैंने पढ़ा, शानदार। अच्छा, मुकुल जी भी बैठे हैं क्या? धन्यवाद आपको। तो ये इतने शानदार इंसान, जिनकी याद में अब रामनाथ कोविंद का क्या इशू आया, इमरजेंसी का भी इशू आया, कितने ही उनके मेमोरीज होंगी जिसके बारे में आप चर्चा कर सकते हैं। मैं सुप्रीम कोर्ट ऑफ इंडिया को एक धन्यवाद देना चाहूंगा। जस्टिस डीवाई चंद्रचूड़ साहब चले गए हैं। देखिए, मैं एक बार कोई एडीआर के इशू में अभी लंदन गया था, तो वहां एक विषय आया कि वीसी के थ्रू, वीडियो कॉन्फ्रेंसिंग के थ्रू सबसे ज्यादा किसी सुप्रीम कोर्ट में सुनवाई हुई, केस सेटल हुए तो इंडिया। तो मुझे भी अच्छा लगा। ये मैं कम्युनिकेट कर दूंगा कि मैं आपके पीछे से बोला हूं। अब आप भी कम्युनिकेट करना उनको, और मैं भी कम्युनिकेट करूंगा कि बहुत बहुत तरीके से उन्होंने कहा। और मुझे लगता है टेक्नोलॉजी का यूज करने के लिए जिसका जिक्र आज इस मंच से हमारे चीफ जस्टिस ऑफ इंडिया कर रहे थे, वो है नेशनल जुडिशियल डेटा ग्रिड, और जिसका कल इन्होंने ट्वीट किया, फिर प्रधानमंत्री श्री नरेंद्र मोदी जी ने उसी ट्वीट को ट्वीट किया। तो आज मीडिया में बड़ी खबर है कि इस तरह के जो चेंजेस भारत में आ रहे हैं, वो हमारे जो पेंडेंसी है केसेस की, उसमें कमी लाने में भी मदद करेंगे, नागरिकों का जीवन भी आसान करेंगे। कौन सा केस चल रहा है, क्या डेट है, कौन से बेंच में आएगा, ये सब चीजें आपको ऑनलाइन उपलब्ध रहेगी। मैं इस अवसर पर, चूंकि बाकी सभी मेहमानों को बोलना है और मुझे जो टाइम निर्धारित किया है उस नहीं, इसमें है लिखा हुआ इसमें है लिखा हुआ तो वही मान लेते हैं अपन, जो लिखा हुआ है। बाकियों को सुनूंगा मैं, क्योंकि मैं लर्नर हूं, ज्यादा सुनने में विश्वास रखता हूं। लेकिन आप सब आए, आप सब लोग आए, आप सबको भी शुभकामना, बधाई। देखिए, कोई आदमी जाने के बाद याद ज्यादा किया क्यों किया जाता है, तो एक कवि ने बहुत ठीक कहा है, जाना तो सबको है ना, समझ लो कि मृत्यु है ना, मृत्यु से डरो कभी, मरो परंतु यो मरो की याद जो करें सभी। बहुत बहुत धन्यवाद।
Thank you very much, sir, for your words of wisdom. Ladies and gentlemen, at this moment, we'd like to request two gentlemen to please join us up on stage. The Chairman and Editor-in-Chief, Republic Media Network, Mr. Arnab Goswami, and the founder of ITV and Rajya Sabha MP, Mr. Kartikeya Sharma, to please come up as well. Thank you very much. Ladies and gentlemen, we have in our midst a legal stalwart who occupies a position of utmost significance within our nation's legal framework, the Attorney General of India, Mr. R. Venkataramani, with over 4 decades of splendid active practice at the Supreme Court. He is one of India's finest jurists, deeply committed to constitutional issues as well as to building India's future legal eagles. As the Attorney General of India, Mr. R. Venkataramani is the custodian of the Constitution, a defender of individual rights, a guardian of the principles that underpin our great nation. Please join me in inviting the guest of honor, the Attorney General of India, Mr. R. Venkataramani, to address the gathering.
Thank you, my dear, whatever we call as the words of Justice Krishna here, comrades and friends, as we call it, in his bright, emotional. So, Comrade Mahesh Jethmalani, thank you for inviting me to here today. Why I use the word, I'll tell you a little later. I brought my prepared speech and I think I'm leaving it on my table. Much of it has been stolen by Chief Justice of India. But I thought Chief Justice always very passionate about justice. His engagement of his mind in varied dimensions of doing justice is remarkable. But today I found something more rare, a rare passion today. Maybe Mr. Jethmalani was standing by his side and telling him that we have a long association with me and my family is something which is, we use something called ineradicable. that rare passion, something very interesting today. I found it so exciting that when I left my prepared speech, which would have probably talked about what cases Mr. Jethmalani argued and so on and so forth, let me only say a few statements. I mean, the minister is here, and I'm sure that you would agree with the Attorney General for making such probably radical statements, bold statements about what the Constitution should do in our country and what good governance should be talking about. So I would probably say that in honor of Mr. Jethmalani, if we have built a grand temple in honor of Lord Ram in Ayodhya, probably we need to build institutional temples in honor of Ram Jethmalani. I have in mind a few institutional temples. One is if history of liberty in this country will be ever written, I say Ram had his mind always what Justice Learned Hand said, liberty lies in the hearts of men. So if ever history had to be written in our country, the way it is being written in some parts of the world, I pass here for a minute to say that unlike what is being written in America or in Europe about the contribution of eminent persons in the legal fraternity to growth of law and justice has not been well attempted here in our country. We need to probably engage in a genre of literature. Women in the legal fraternity have been preeminently and fundamentally responsible for certain entrenchment of certain doctrines as part of our law and legal system. So therefore, I would like to say that let us begin to chronicle the contributions of such eminent persons in the legal fraternity who have made the trajectory of law and justice in our country very, very different from what we thought it will be like to be in 1950. So my first contribution would be to ask those of you here, probably Mahesh should have thought about a bigger auditorium where more and more willing minds and inclined minds would be part of a contribution, both in writing and otherwise, would have been here. I invite each and every one of you who would like to be part of this engagement to write about such eminent persons as an integral part of the graph of Indian constitutional history and justice administration. The second I would like to probably invite is, as I took over, of course, if the Attorney General cannot think on his feet, what else he is fit for? So as I took over, I thought that what Jethmalani made a difference in our, I said, the history of liberty in our country. The eminent personalities, they talk about the basic structure of the Constitution. So everything about basic structure is about liberty. You can build so many dimensions and about liberty and their connection to basic structure, but I'm not going to talk about that. But I thought the more passionate engagement of Mr. Jethmalani about liberty and how he thought that's the fulcrum of the constitutional values, it's important for us today to talk about a National Institute for Criminal Justice Administration. I think about the most common women and men in our country who face the onslaughts of justice administration without those carrying hands and comforting or solace giving aid and assistance to the state. I conceive that this kind of an institution will be able to fill a huge gap in criminal justice administration. We are talking about the pendency of cases in trial courts, and we talk about the unfortunate men and women who get into prisons without seeing a day of hope as quickly as they would like to have. I look at all that very dark gray landscape, which seem to be part of our criminal justice system. Why can't we think about removing the dark gray landscape and make it more brighter? And I think that's a great contribution, a commitment as an Attorney General I can think about. And I'll probably conclude with a few personal recollections. In 1980, we were arguing a preventive detention case. I was just about 1 year in the Supreme Court bar, sitting in the Chief Justice's court, listening to him, his stern, full, majestic voice. I could still find that ringing in my ears. It never faded away. Many of us who are with him for long know that the stern, full, majestic voice has become part of our, life in the court and chronicles, all over. In 1986, I was appearing on behalf of a very unfortunate Adivasi woman from Gujarat who was subjected to a sexual assault in police stations. One of the local legal aid organizations asked me, how do you go about this case? And they had a feeling that if you go to a local magistrate's court, sure, justice will not be done. So when I was asked, how do we go about this case, I said, let us ask the Supreme Court to intervene in a matter like this. Now, what else will liberty can mean if Supreme Court will not reach out to the rescue of such unfortunate women? We built a case on violation of 14 and 21. The Supreme Court came to our rescue and was arguing that matter in the afternoon before Chief Justice Bhagavati. Mr. Jethmalani was in the court. So after a couple of hours after about 4:30, I thought he would have left the court. But he was in the coffee house waiting for a few people to be talking to him. And then he called me inside and said, I think the one thing probably you would do good for the country is to keep liberty burning in your heart. And I think that's a great, warm advice given to me. And I think I've been able to keep that in my heart. And I'm sure that many more occasions like this where beyond passion and emotion, much more intellectual and engaged conversations and dialogues and discourses, which will probably enrich what I would probably call again the life and comfort and solace of the least or the most disadvantaged and the least cared for in our country. If justice cannot mean anything to them, I think justice does not mean anything to any one of us. So I would probably only say that Mr. Ram is probably standing by my side as he stood by the side of Chief Justice of India to pat him on his back, to be as passionate as possible about liberty and justice. And I think I'll continue to hear his voice by my side. I thank Mr. Mahesh Jethmalani for giving this opportunity.
Thank you so much, sir. Now, to formally introduce the topic of the 4th edition of the Ram Jethmalani Lecture Series, it is a privilege to invite the Chairman and Editor-in-Chief of Republic Media Network, Mr. Arnab Goswami. Aside from his long association with Ram Jethmalani, both on air and off air, which he has recounted often while hosting the eminent lecture series from its inception, Mr. Goswami has a topic that lies at the heart of India's constitutional jurisprudence, the basic structure doctrine. So I request, ladies and gentlemen, Mr. Arnab Goswami.
Thank you very much, Rini. And it is a complete and absolute privilege to be here among you. I am very deeply honored to be standing today. For me, it's not just a humbling moment to be introducing this subject before such an accomplished audience and amongst those who have scripted the great legal legacy of this country, whose work within the court and within the system of jurisprudence together binds the unshakable faith of the country in the rule of law in India. But I must say, and Mahesh, you know this, that it is personally very, very special to me, given my deep and very memorable association with your father, the legendary Ram Jethmalani. And I'm deeply grateful to you, Mahesh, for this momentous annual lecture series, which has become an unmatched platform for legal deliberation and thought, and for allowing our network to associate with it. I'm also very humbled to be here amongst the Honorable Law Minister, the most respected Mr. Attorney General, legal giants of India, Mr. Fali Nariman, a legal luminary whose wisdom and whose integrity have left such an indelible mark on our legal heritage. We are so honored to have you amongst us, Justice Deepak Mishra, Mr. Gurumurthy, Mr. Sham Dewan, and all your unwavering commitment to justice, thought, and rule of law has left a deep impact on our system. Now, Mr. Jethmalani's quick wit and sharp wit, I've been talking to Mahesh about it. What would he have said of this and what would he have said of that? But let me say to you, Mahesh, that the subject that we have placed before us today is a subject he would have loved to participate in himself. I was thinking about it. Through its vicissitudes, its complexities, and through its very contradictions, and through the fact that both sides, both the executive and the judiciary, have unmatched skill in articulating their point of view legally and rhetorically. This is the kind of subject that people often avoid. I'm a great believer that things that people avoid should be the things that we sort of pinpoint on. And that is the kind of dialectic that is needed in this country today. Now, ladies and gentlemen, to set the subject, and I will keep it as short as I can. I have some personal limitations in keeping to my time, as you all know. But I shall say this, that we are standing in 2023, which is the birth centenary of Ram Jethmalani. It is also the 50th year of the landmark judgment in the Keshavananda Bharati versus State of Kerala case. And today, through this topic, we hope to delve into the fascinating, unspoken world very often of the basic structure doctrine, a concept that has significantly shaped the trajectory of Indian constitutional law and has had a profound impact on our great democracy. And this doctrine is born out of the landmark Keshavananda Bharati case of 1973. Now, that judgment embedded the basic structure doctrine 50 years back in Indian jurisprudence to gatekeep and guard against fundamental changes to our constitution. We are all aware that that judgment itself was a 7-6 verdict, hotly debated, keenly argued, and there were two sides. And while instances like the emergency saw India's darkest hour of the basic doctrine, the concern on the other side is whether the basic doctrine transgresses the power vested in the executive. And there is discomfort over it. Whether it transgresses Parliament, which represents the people's will. Whether the great tradition of the basic structure doctrine has served us well as a nation and will continue to serve us well for the next century is the question we shall seek to answer today in the heart of the nation's capital. The basic structure doctrine, in a sense, is aimed at ensuring that the power of constitutional amendment vested in the Parliament is not misused in a manner that alters the identity of the Constitution. And that's what made the Keshavananda Bharati case so special. And that's exactly what was challenged 4 years later in a different context, as we all know, in the habeas corpus case. Now, this rests upon several core components. It rests upon, one, the supremacy of the Constitution. It rests upon the true secular character of our country. It rests upon, most importantly, the separation of powers among the legislature, the executive, and the judiciary. And it also rests on the commitment of the federal character of our being. These principles collectively form the bedrock of the constitutional identity as per the doctrine. This doctrine plays a pivotal role in safeguarding the supremacy of the Constitution over politics that can sometimes challenge the constitutional integrity itself. These are difficult subjects. Let's not avoid the subjects today. I say let's have an open debate. This debate is going to be watched by people across the country and around the world. And I think the greatest aspect of our democracy is we can sit in the capital of the world's largest democracy and openly discuss subjects, not with an element of amorphousness, but directness, and we can have eminent people like this on the dais to take it forward. It's brilliant. It's so exciting. Ladies and gentlemen, this principle that the Constitution is the supreme, and no amendments should be allowed that can undermine our core values as a nation to the Constitution, is seen as very crucial by many who support the doctrine in its absolute vis-a-vis the preservation of the democratic essence of our nation to ensure that no transient democratically elected majority can tinker with the fundamental principles upon which our constitution stands. However, it is also essential to outrightly acknowledge that not everyone has been in complete agreement regarding the basic structure doctrine. Some have questioned its scope and its application, raising severe concerns about potential judicial overreach, a subject which we must openly discuss now. Openly discuss. Why not? I believe in discussing everything. But the fact is, it sparks a healthy democratic debate about whether limitations exist, if at all. Now, ladies and gentlemen, there is also an argument by some who express concern of any one pillar assuming excessive control, and whether the basic structure doctrine, in the way that it has played out so far in our great nation, provides for the essential harmonious checks and balances within our democratic system so as to prevent any potential transgression. So essentially, the issue is transgression. Essentially, the issue at the very core is transgression. Who has the right to transgress, and what are the circumstances to transgress, and are there limitations to transgressions and allowances on transgression? I think the basic word we need to debate is transgression. Undoubtedly, the basic structure doctrine has been put to its ultimate test, and it rose to the occasion when India faced one of its darkest hours. The most infamous period of the emergency, declared by Indira Gandhi in 1975, marked a time when the very soul of our democracy was put under siege by Indira Gandhi. It was a moment when the doctrine faced its most significant challenge, and the stakes could not have been higher. Citizens were detained without trial. Total censorship was imposed on the media. There were power cuts at newspaper printing presses. There was jailing of free speech, and with it, the nation's constitutional rights, all by one sweep of an executive decision. It was the darkest chapter in India's history, a complete nightmare when the principles of democracy and rule of law were shattered, and it was the basic structure doctrine which emerged as a very powerful instrument of justice. There are landmark cases we hope we discuss, and also the lessons upon them, the role of the judiciary and the role of the executive. Ladies and gentlemen, from the Minerva Mills case of 1980, which ruled that a limited power was placed on the basic features of, to the L. Chandrakumar case of 1977, which said that judicial review under Article 32 and 226 is part of the basic structure. The significance of this concept in the Indian Constitution and jurisprudence is undeniable. Now, there is a context to this, and as we crisscross to the present day, and as a newsman, ladies and gentlemen, I often see the questions before us in terms of events. Pivotal legislations guided by the principles coded in our directive principles are on the cards. Matters of electoral politics increasingly are turning to court. They are turning to courtroom hearings. It has become a regular feature. It has become an interesting feature. In fact, the court was compelled to comment recently that certain matters are in the political realm, and the courts should not come into it. Issues that were otherwise settled by parliamentary debate, because of the polarized situation in our politics, are seeking urgent hearings in the honorable highest courts of the land for solutions. What should be the entry point? What should be avoided? We seek to deliberate this before us today. And finally, while it is healthy to engage in debates about the scope and limitations, I think we must all recognize the doctrine's enduring significance in upholding the values that define our great nation. The fundamental question, would we have been a better country without a basic structure, or would we have not? That is the principle we must debate. The basic structure doctrine, in my view, is a cornerstone of our constitutional democracy, the North Star through the complexities of constitutional interpretation and limitation and implementation. And the topic today, has it served us well as a nation? Let us all begin in a very exciting and thoughtful exploration of this vital aspect of our constitutional heritage and its role in our great future with the finest legal minds of India and the great spirit of Ram Jethmalani, who guides us all. Thank you very much. Thank you.
Thank you very much, Mr. Arnab Goswami. Ladies and gentlemen, he is the doyen of the bar, the legal legend, the Bhishma Pitama of the legal community. We have the distinct honor and privilege of having such a towering figure in the world of law and jurisprudence among us, a luminary whose name is synonymous with excellence and integrity in the legal field. Ladies and gentlemen, Mr. Fali Nariman is a legal titan whose illustrious career spans decades and whose contributions have left an indelible mark on the landscape of Indian law. His journey through the corridors of justice is a testament to his unwavering commitment to upholding the principles of justice, fairness, and the rule of law. As we invite Mr. Nariman for his keynote address today, we're not only welcoming a legal luminary, but also a role model and an inspiration for generations of legal practitioners and aspiring advocates. His legacy serves as a beacon of hope for those who believe in the transformative power of the law to shape a more just and equitable society. Ladies and gentlemen, we give to you Mr. Fali Sam Nariman to deliver the keynote address.
Thank you. Honorable Minister of Law and Justice, it's very good to have met you and seen you and heard you. Former Chief Justice Deepak Mishra, my friend Guru Murthy, whom I am delighted to see after so many years, but fortunately we have met each other and had a bit of gups up whilst the speakers were on the floor. And my friend Mr. Goswami, who just delivered a very strident expose. Why not a debate? He's quite right. Of course you have a debate. Nobody must suppress any debate on any subject. And this subject is actually well worded as well. I know I'm listed to speak only on a set topic, but let me tell you frankly that I have stirred out of my home this evening principally to participate in an event. The event being the centenary celebration of not only a great advocate, but also a great maverick who was also my friend. And this is why I first crave your indulgence to pay my tribute to his memory. It was said of a famous US attorney that he was such a superb advocate that he made money on the side by selling tape recordings of his final arguments in court. Jethmalani was by common acclaim a superb advocate. It was a treat to see and to hear him, and those of you who didn't, is a great misfortune. Even though he never sold tape recordings of his arguments in court. Pushing 97, which is unstoppable, record-breaking, 70 odd years at the bar, Ram sadly left us on 8 September 2019 after setting up, and this is very important, a high benchmark of professional excellence about which you heard the Chief Justice expound in a very brilliant memorial address. In life, one has to be fortunate in one's given name. If your name has 4 letters, like Nani, N-A-N-I, for instance, it carries you a long way as it carried the great Nani Palkhiwala in his fascinating journey through life and the law. But if your first name is only a 3-letter word, like Ram, it may carry you even further simply because Ram is on the lips of every God-fearing Indian morning, noon, and night. It is great that his son has remembered to celebrate his 100th birth anniversary. But I have a small grievance, and I must ventilate it here. Mahesh's illustrious father, if he was with us, would have celebrated this occasion with far more aplomb, with far more panache. In the first place, he would not have planned a lecture in this hall at all. Instead, ladies and gentlemen, if I know him and those of us who knew him, he would have hosted a party in far more salubrious surroundings, inviting you all and served spiked beverages to all present. But alas, it's not to be. So now permit me to say a few words on the subject chosen for this memorial lecture. The basic structure doctrine is inextricably linked to what has been mentioned in one article of the Constitution, the Amendment Article 368, the only article dealing with substantive amendments to the Constitution. The constraints on constitutional amendment have been and are attempts by courts, not just in India, but around other parts of the world as well, to ensure the survival of democratic institutions and, to use the phrase of Mahesh, extremely well put, serve the nation well. Very important. Serve the nation well. In India, in the past 50 years, 1973 to 2023, the application of the doctrine has followed this particular pattern. First, the doctrine of basic structure is now established and accepted by 6 nation states around the world: Bangladesh, Pakistan, Uganda, Israel, Malaysia, and a small country called Belize in Central America. Second, let me give you how matters stand in India between 1973, when the doctrine was first propounded, and 2023. Since 1950, we have had 105 constitutional amendment acts under Article 368, which 60 new articles were inserted in the Constitution. 17 originally enacted articles have been removed, and 154 originally enacted articles have been substituted or amended. This is not my cleverness which brings this out, not at all. It is derived from a complete list of amendments which you will find in Wikipedia. You just download Wikipedia and you will get the amendments, and you just have to look through it. Third and most important, the basic structure doctrine has been invoked so far sparingly by India's Supreme Court. As you will appreciate from the following figures, between 1973, the decision in Keshavananda, and the current year, 2023, there have been 22 reported cases in which constitutional amendments have been challenged on the basic structure doctrine, out of which in 7 reported cases, 7 in 50 years, the challenge provisions have been struck down by the Supreme Court of India by invoking the basic structure doctrine. So it is impossible to generalize. You can certainly look at any particular case and criticize it, and there a debate would be meaningful. In 15 reported cases, the challenge on the basic structure doctrine has been repelled and rejected. That is to say, the validity of the challenged constitutional amendments have been upheld by the court. Now let's go further. The striking down has always been on some principle related to what I call good judicial governance. Not interfering judicial governance, but good judicial governance. In constitutional law, especially in constitutions that prevail in all the 56 Commonwealth countries around the world, governance is by three organs of the state: the legislature, here parliament, in elsewhere parliament, called differently in Knesset in Israel, etc., the executive and the judiciary. And in matters of judicial governance, you must know that there exists a theory about its legitimacy, expounded by a renowned academic jurist of the 20th century, a man called Ronald Dworkin. He's quite famous around the world. Dworkin had said, and I mentioned this, present day judges who may have had nothing to do with the written constitution when it was first framed, by reason of their position as judges, have become and must act like partners with the framers of the constitution in an ongoing project, since it is and always will be an ongoing project, to interpret a historic document in the best possible light. And he went on to say, and these are his words and not mine, judges may therefore sometimes make new law either covertly or explicitly, but when they do so, they should act as, and this is very important, when they do so, they should act as deputy to the appropriate legislature enacting the law that they suppose the legislature would enact if seized of the problem. This has since become known around the world, and you must also know this, as the Hercules technique of constitutional adjudication. Does the Herculean technique of constitutional adjudication apply in India? It does, because it is incorporated in an originally enacted Article 142 of the Constitution, an article which provides that in the exercise of its jurisdiction, the Supreme Court of India, and the Supreme Court alone, not the High Court, not the other courts, not the District Court, the Supreme Court of India may pass, and I quote from Article 142, may pass such decree or order in a case as is necessary for doing complete justice in any cause or matter pending before it. And the word complete justice in Article 142 is deliberately left undefined. It is something which, in the opinion of the Supreme Court and the Supreme Court alone, will, in the words of Mahesh Jethmalani, serve the nation well. This is important once again. Hence, for instance, and this you must remember this instance, when members of India's parliament during the period of the internal emergency, which was June 1975 to March 1977, those who were not in jail under preventive detention could not attend this session. And there were many. When members of India's parliament during this emergency had added clauses 4 and 5 to Article 368 by the Constitution 42nd Amendment Act 1976, clauses that completely precluded the court from calling in question any constitutional amendment on any ground whatever, with an added clause declaring that there shall be no limitation whatever on the constituent power of Parliament to amend by way of addition, variation, or repeal the provisions of Article 368. And when this amendment was challenged, the then members of the Supreme Court, in rare unanimity, struck down clauses 4 and 5 of 368 because of its excessively overbroad formulation. The court holding that in excluding all judicial review over any constitutional amendment there was a violation of the basic structure doctrine. Individual members of the public may from time to time get worried. I sometimes am, with orders and decisions given by individual judges of the Supreme Court. But please, never lose faith in the higher judiciary as an institution, as one of the three constitutional organs of good governance. As you all know, the basic structure doctrine got established initially in 1973 in Keshavananda with a very narrow majority of judges in favor, 7 judges in a bench of 13. It was held by the majority, 7-6, that the basic features of a written constitution could not be taken away by an amendment of the constitution. But you also need to know something more, that in November 1975, a bench of 13 judges was once again reconstituted by Chief Justice Ray to reconsider the correctness of the majority view expressed in Keshavananda. And in this bench of 13 judges, there were 8 new judges, all appointed after Keshavananda, replacing those who had retired at age 65, which is the constitutional age of retirement. And this new bench of 13 judges heard arguments for on 2 days of November 10th and November 11th, 1975. And on the morning of the third day, 12th of November 1975, when the court of 13 judges reassembled at 11 a.m., Chief Justice Ray, presiding over the 13-judge bench, suddenly and peremptorily announced, "This bench stands dissolved." And all the judges rose and went back to their chambers. And this was only because Chief Justice Ray was satisfied that the doctrine of basic structure was not to be reconsidered by any of his 12 colleagues. And this has been recorded in a constitutional law book, which is now famous, Mr. Sirvai's Constitutional Law of India, where he expressly mentions this. And please remember that he was not interested, he was not a person who had any bias. On the contrary, he was the person who had appeared for government in Keshavananda, and as making the principal argument even before the Attorney General, Mr. Nirande. This is not all. In the year 2007, the basic structure doctrine was once again questioned, and yet again a bench, this time of 9 justices, unanimously affirmed the doctrine of basic structure. But lastly, and most significantly, the basic structure doctrine, or what is known as the essential features doctrine, which is its other name, has now acquired a place of permanence in constitutional adjudication, simply because, and you'd be surprised to know this, it was initiated by India's parliament itself. This is how it was done. There is an article in the Constitution 359, which had been enacted in 1950. And it states that if during any period when a proclamation of emergency is in operation because of internal emergency or external emergency, the President of India, which in effect means the central government, is specifically empowered by order to suspend the right to move any court for the enforcement of all or any of the rights conferred by Part 3 of the Constitution, that is, all or any fundamental rights, even though in ordinary times the enforcement of all or any fundamental right is guaranteed by Article 32 of the Constitution. So also, during the period of an emergency, all proceedings in court for enforcement of fundamental rights according to Article 369 as enacted, are to remain totally suspended for the period during which the proclamation of emergency is in force. But after the lifting of the oppressive internal emergency imposed on 25th June 1975, and after the sixth general election of March 77, India's newly constituted parliament met and expressly declared by Section 40 of the Constitution Amendment Act 1978 that the right to move any court for the enforcement of rights conferred by Articles 20 and 21 even during the period of an emergency can never be suspended. To paraphrase this in legal language, it was the considered view of India's parliament, not the view of India's higher judiciary, but of India's parliament, that the fundamental right to life and liberty in Articles 20 and 21 were a part of the basic structure of the Constitution. Because in the statement of objects and reasons for this amendment, it had been expressly stated by the then government in office that this was done in order, and I quote, to check the misuse by the executive of the emergency provision. In other words, the right to life and liberty from then onwards had, according to Parliament itself, been a part of the basic structure of the Constitution. I would like to end this intervention of mine with a wish. I wish that the basic structure doctrine continues so long as people, particularly ordinary people, choose to remember that great human rights advocate of his time, Ram Jethmalani. Thank you very much.
Ladies and gentlemen, we can surely give a bigger round of applause. Paliji, thank you so much for setting up this debate for us. And I know the round of applause is for you, and Ramji will be looking upon us, feeling very happy that you are here today to set up this centenary lecture. With that, ladies and gentlemen, the next speaker this evening, you all remember as the former Chief Justice of India. Enrolled to the bar in 1977, Justice Mishra has spent 22 years as a judge, starting from the Odisha High Court, the Chief Justice in Patna, then Madhya Pradesh, then as a judge of the Supreme Court, and finally retiring as the Chief in October 2018. Let's please put our hands together for Justice Deepak Mishra.
Sri Arjun Ram Meghwal, Honorable Law Minister, Mr. Polias Nariman, Senior Advocate, Mr. Mahesh Jethmalani, Senior Advocate, Mr. Sham Devan, Senior Advocate, Mr. Gurumurthy, Mr. Kartikeya Sharma, Member of Parliament, Mr. Goswami, ladies and gentlemen. Today, I must say, without any kind of hesitation or innovation, that it's a great day. I always appreciated late Ram Jethmalani for three fundamental, perceptible reasons. In the year 2011, Mr. Nariman, Mr. Jethmalani, and myself shared a platform in the university. I quoted two lines from a Sanskrit prescription on how a plane should be drafted. I had translated it into English. Late Jethmalani asked for a copy and told me, I'm not asking you Just like that, I want to feed my curiosity. That was the great intellectual curiosity of late Jethmalani. The young students or the young lawyers who are present here today must understand and try to develop the intellectual curiosity. In that speech, he spoke a line: whatever I do with a clear conscience. Look at the courage of the man. Third, whatever I have read and learned by meeting him, he had an incomparable presence of mind that epitomized originality. Today, with the centenary lecture, I feel proud and honored to be a speaker here. Presently, let me focus on the topic. Has the basic structure doctrine served the nation itself? Nation well. According to the scientists and the rationalists, if you pose a question, it is fundamental to proceed in an empirical manner, and then only you will get a correct answer. Having scanned the anatomy of the question, which has been extremely intelligently framed by Mr. Mahesh Jethmalani, the answer should be given with utmost immediacy. And the answer is, ladies and gentlemen, a capital yes. It has served the nation well. To elaborate, the basic structure doctrine has served the nation and saved and stabilized the constitutional democracy and the core values with excellent solidity and virtuosity. I deliberately add this word virtuosity without allowing any space for doubt. Why do I say so? I cannot make a statement if it's Dixit and rest. I am obligated as a student of law to give reasons. When any doctrine is discussed, it's necessary to pose three questions. Firstly, the validity of its origin. Secondly, serviceability of the same for the cause it's conceived. And thirdly, necessity of its continuance tested on the progressive parameters without adopting a doctrinaire pedantic approach. Before I proceed to state the justness of the doctrine, the origin of it, which I would like to call cause of the cause, or for that matter, essence of the essential, has to be kept in mind. It is the summum bonum of our constitutional jurisprudence. That is, the Constitution is sovereign and its supremacy is unquestionable. There is no necessity to think that the judiciary is trying to reign supreme. Judiciary functions under the Constitution and follows the constitutional values, norms, conventions, framework, silences, or abeyance. Let's go in the history for a moment. Initially, the Supreme Court understood Article 368 in the literal sense. The real test arose in Gorakhnath, where court had to deal with many an amendment. Prior to that, two learned judges had expressed strong dissent in Sajan Singh. In Gorakhnath, the view the court took eventually led to sped up amendments and gave rise to Kesman Bharati's case. The principle laid down there is well known. Because of prolixity of judgments, a senior counsel wrote a book and got it released in 2011, stating that the majority view in Kesman Bharati is not the ratio. I must tell you, the view is totally wrong. The ratio is absolutely clear. The parliament has the power to amend the constitution, but the power is not unlimited. It doesn't have the power to amend the basic structure of the constitution. The majority of the judges also discussed some of the features of the basic structure doctrine. They can be encapsulated as rule of law, supremacy of the constitution, democratic form of government, judicial review, independence of the judiciary, separation of powers, the secular and federal character of the Constitution. It was stated that the basic features are easily decipherable from the entire constitutional scheme. I really don't understand why the Lawrence Senior Council and many others still think the ratio is not clear. Scrutinized oppositely, three aspects emerge. Firstly, the majority view is clear as day with regard to the nature and character of Article 368 of the Constitution. Secondly, given the power to amend, the article cannot be taken recourse to, assume unlimited power, or destroy and abrogate the Constitution, or to put it differently, in exercise of the said power, the identity and personality of the Constitution cannot be altered. Thirdly, the Constitution being supreme document, the basic features are unamendable. The interpretation is within the keen understanding of the Constitution. It's neither extra-constitutional, nor alien to the Constitution, nor meta-constitutional. It encompasses every facet of the Constitution to establish the ground norm, that is, unchangeability of the identity of our organic Constitution. All of you, I assume, must have gone through this decision. I am compelled to say, being intellectually bound to my concerns, that the origin of the doctrine is flawless. Chief Justice Sikri quoted a passage from the decision in Reeds versus Baldwin. Look at the poetic prose. It states, in modern times, opinions have sometimes been expressed to the effect that natural justice is so vague as to be practically meaningless. But I would regard them as tainted by the perennial fallacy that because something cannot be cut and dried or nicely weighed or measured, therefore it doesn't exist. I can speak with certitude. All of you present here and all of the members of the great country, the citizens, and who are not there can never say now that the principle of natural justice is vague. Any lawyer worth his salt will always argue natural justice cannot be ignored. Similarly, basic structure doctrine can never be ignored. How to test a doctrine? The correctness, acceptability, serviceability, and the solidity of any legal theory is put to test when the occasion arises. The basic structure doctrine did not have to wait long. In 1975, Article 329A by 39th Amendment came into existence. The said amendment made an, shall I say, adroit endeavor or maladroit effort to immunize the elections of the Prime Minister and Lok Sabha Speaker from scrutiny by the judiciary and further to nullify the judgment of the Allahabad High Court. The Constitution Bench, presided by Chief Justice N. Roy and Indira Nehru Gandhi, said that the court was proceeding with the hearing on the assumption that it is not necessary, I repeat, it's not necessary to challenge the majority view in Keswanand Bharati's case. I must say and remind this House, it was eventual acceptance by the non-believer in basic structure doctrine. I'll refer to another amendment, Mr. Nariman has dealt with it in a different way, that came in quick proximity, the 42nd Amendment. It had been brought with the intention to reduce the power of judicial review, to treat the directive principles of state policy to a primacy over fundamental rights, and further asserting parliamentary supremacy or parliamentary sovereignty by state, stating that no constitutional amendment can be called in question in any court on any ground. By the said article introduction to 368, all fundamental articles, if I'm permitted to say, went to the Arabian Seas or the Bay of Bengal. They fell into insignificance. The harmony between Part 3 and Part 4 of the Constitution was destroyed. When challenged Chief Justice Y.B. Chandrachud in Minerva Mills case said. Since the Constitution had conferred a limited amending power on the Parliament cannot, under exercise of that limited power, enlarge the very power into an absolute power. By the 42nd Amendment, the real essence of the Constitution was destroyed. The court did the needful. Mr. Arnab Goswami raised a question today that should be a debate. I must ask a question to everyone and every curious student of law. What would have been the fate of this nation and its citizens had not the court taken aid of the basic structure doctrine and declared the disturbing part of 39th Amendment and wholly unacceptable and devastating amendment occurring in 42nd Amendment as unconstitutional. The result would have been the cherished ideals and marrows of democracy would have been guillotined, and the nation state would have faced, to quote a phrase from great John Marshall, a solemn mockery of the Constitution. And more significantly, the real judicial review would have melted into nothingness, and the citizens of this great democratic polity would have turned into subjects. I hope all of you understand the distinction between a citizen and subjects. I must refer to NJSC case. All of you know the amendment was struck down as that infringed the judicial independence, which is a basic structure of the Constitution of India. In I.R. Coelho case, the 9 judges unanimously said, you cannot put a legislation in the 9th schedule and say it is human. What has it actually done? If you go deep, think deep, it has really empowered the citizens of India not to suffer an impermissible law because of grant of immunity. An impermissible immunity. Now let's come to the rights test. The rights test and the concept test have put the individual rights and constitutional values on the elevated platform. The citizens' right recognized under the Constitution, according to me, can never be marginalized, and it would not have been possible without the basic structure doctrine. Since that, every individual right would have paled into total insignificance. There would have been no expansion of Articles 14, 19, and 21. The apex court could not have propounded the values of individual dignity, privacy, choice, freedom of expression, equality in the true sense, gender rights, constitutional tort, and other aspects, all founded on acceptable, realistic constitutional principles. the entire nation state would have paved on the path of regression, and the citizenry rights would have gradually moved into unredeemable hollowness. There can be no scintilla of doubt, no trace of doubt, no speck of doubt that the basic structure doctrine stabilizes constitutionalism, constitutional governance, rule of law, and legitimizes all actions. Let it be told today that the basic structure doctrine is one that is directed against anarchy. It has basically acted a navigational compass to enable the judges to navigate the journey of constitutional interpretation in the proper direction, and also guided and enriched our constitutional progress. It is the elan vital and the filament of the constitutional principles and values. In conclusion, I would like to say that the basic structure doctrine is neither an enigma nor in the realm of mysticism. It is here in the elements with true fixed continuing quality. I repeat, it is here in the elements with true fixed continuing quality. Why? To serve, protect, and shape the nation, because it is the spirit, fundamental essence, and conscience of the Constitution. None of us should forget that basic structure doctrine remains the most natural constant. I borrow these words from physics. Natural, constant, and diligently searched rock. I borrow these words from philosophy. Diligently searched rock of our constitutional democracy and philosophy. Never mortgage our constitutional democracy. Never, never barter it. Thank you. Thank you very much.
Justice Mishra, many, many, many thanks. Our next speaker this evening is one of the most impactful, unabashed, and influential voices in the country, a chartered accountant who wields his pen as the editor of Tughlaq. He's never shied away from either telling truth to power or controversy. Let's give a welcome round of applause to Swaminathan Gurumurthy.
Honorable Minister Sri Arjun Mengwal, Justice Deepak Mishra, my friend Salin Nariman, Mr. Sham Diwan, with whose father I had very intense relationship, and he was one of the persons who molded me, and Arnab Goswami, my good friend, and Mahesh, who thought of inviting me because he felt that there should be a voice outside the jurisprudential group, which is both the judges and the lawyers put together. You know, it is my fortune, my pride, an opportunity for me to share my thoughts, not as a lawyer, but as someone who had come in contact with law, fell in love with law, became passionate about law, because of a series of accidents, coherent accidents, which took place in my life, starting from emergency and the days before. You know, we were all underground at that time. We couldn't go to our houses. And I had just then qualified as a chartered accountant and got married also. So it was at that time I came to know the essence of the Constitution, the fundamental right, the need for it. Otherwise, it was just a piece of paper. Nobody knew what fundamental right meant before probably the emergency was imposed. Very few people knew about its impact, maybe most in the field of commerce or property. There was no idea of what it means to the normal, ordinary human being. I was given the responsibility of maintaining 150 families to provide rations for them who were in jail. They had done nothing wrong. So I knew what it means to have fundamental rights, to be outside, how to approach the judiciary. This is what made me to study the Constitution in depth. In fact, emergency became the first major impact on me to study the Constitution. And before I go into what transformed me from being a chartered accountant into someone who had developed such passion for law, I will talk about Ram Jethmalani. You know, Ram and Fali and people like them are the ones who groomed me, encouraged me. And they found that, you know, I was not a lawyer, but they never discriminated my ideas on law. I could put provocative questions to them, contrary questions to them, even questioning their very idea about what they were proposing to argue in courts. They would tolerate it, they would encourage it. In fact, I was just sharing with Falin Harriman how in the Indian Express demolition case we worked. He said how much work we put. He also said how little work is being put today by the bar. It's a comparison. How the government of India functions, from the allocation of business rules to the authentication of document rules. Because the government of India said the secretary signing on behalf of the government of India doesn't have the authority to give sanction for the building plan. The government disowned the whole thing. So we had to construct the whole Article 73 downwards to how a secretary signs, meaning the President of India signing. It was a 72-page affidavit which he had to file in the Supreme Court because the government disowned its own signature. You know, this is how law develops. Law develops by hard work, by the passion to fight for rights. So when I started with Ram, you know, he was one of the most comfortable human beings. First of all, leave law aside. Such a comfortable human being. I said, Ram, you are wrong. He will listen to it. We will all be shouting and talking. He will be reading as if nothing is happening outside. And he will read the judgments which were quoted against him. And we would have 20 judgments in favor of what we have to speak. Ram will find fault in the judgment that have been quoted. And he will say that to find holes in the judgments of the opponents is what will win the case for you. Not that you quote alternative judgments to present your viewpoints. These are all brilliant legal strategies to which I was initiated when I was just 27, 28. An opportunity which I got purely out of accident of being the advisor to Ramnath Goenka, who had to face the toughest time in terms of government attack on him during the emergency and afterwards, even after the emergency, the building demolition case, the customs duty case, and all the cases that were launched. 300 cases were launched in a period of 30 days. All these things we had to fight, and perforce we had to become lawyers. In Indian Express, almost 6-7 people who had nothing to do with law turned to be good lawyers, thanks to the kind of assault that the government made. And we had to defend that institution and the civil rights which the institution represented. That's how I came in contact with Fali. That's how I came in contact with Nariman, Anil Diwan, to stay. It all started with Nani Palkiwala. Then Sirwai. I will tell you some of these things. This anecdotal effect of the association I had with all these people. Unbelievable. No university, no law textbook, no library can give the kind of knowledge which I could get by my association with these people. So about Ram, you see, Ram, somebody asked how many times he was Rajya Sabha member. I think our minister asked. He was a Rajya Sabha member 4 times. Of course, he was in Lok Sabha. He was in Rajya Sabha member 4 times. He was Shiv Sena Rajya Sabha member. He was Janata Dal Rajya Sabha member. He was BJP Rajya Sabha member. And he was RJD Rajya Sabha member. He completely unified India. The man had immense, he had a huge heart. In fact, he told me, Guru, will you help me to defend Lalu Yadav? I said, Ram. You see, Ram and me had a very open exchange on many issues. You see, I was also called a fighter against, a crusader against corruption. I would always screen a client 20 times. I will take certificate from my friends that I can take him as a client, because tomorrow somebody should not say that I have taken a wrong client or benefited by a wrong association. But Ram will take the most acknowledged rascal and defend his case. And still he was called a crusader against corruption. I said, Ram, how lucky you are. We are giving up 90% of our opportunities to get the name that we are fighting against corruption. But you are able to fight against corruption, call a crusader against corruption, and at the same time represent these people and make money out of them. In fact, a very interesting dialogue took place between Ramnath Goenka and Ram Jethmalani. In fact, Fali Nariman will be very happy to listen to that. Ramnathji's one of the greatest pride is that none of the senior councils would charge him. Guru, Nani doesn't charge me. Fali doesn't charge me. Ram doesn't charge me. Soli doesn't charge me. Ramnathji used to feel so proud that these great guys are not charging him. In fact, he showed me the bill which Fali Nariman had sent after completing the arguments on the demolition case. And almost 35-40 days the case went on. I think it was after the Keshavananda case, it was the longest case argued before the Supreme Court till then. So when that bill showed that Fali had charged him only for the clerkage. He must have shown that bill to Fali. He must have shown this to 100 people, not to praise you, but to make others feel how important Goenka was. So you must understand, Arun Shourie used to say, Goenka is Article 19(1)(a). He represented the freedom of India. It is not the press freedom of today. You know, those who had worked in the Indian Express those days, the kind of troubles they had undergone, salary deferment, salary cut. These are all the things which journalists underwent to defend press freedom. So Article 19(1)(a) was represented by Ramnath Goenka at the time. And so Ramnath Goenka asked Ram, you are defending so many people pro bono. How are you making your money? And Ram said, that's a very simple formula, Ramnathji. I make money depending upon the trouble my client is in and the weight of his purse. This is how he said, I make money so that I can do pro bono work. You know, these are all things. With how many tall people we moved. Where are those tall people today? In fact, this is how I am going to end my speech. That what we need today is not tall legal brains, not tall judges, not tall media men, but tall people. Tall men, sun crown. This is what we need. Now, going into what is my personal qualification to be here. You know, I am a chartered accountant, but chartered accountants think I am not a chartered accountant. I am a journalist. Journalists think I am not a journalist. I am a chartered accountant. But I am happy ultimately somewhere I have been asked to share my thoughts on a subject on which I have developed some empirical skills. And I am happy this audience of people of jurisprudence are listening to me, which even my own profession and the adopted profession as a journalist has not afforded me the chance. So my first qualification is that I am a friend of Ram. That is why I first felt that I should be present here. And my next qualification is that I have to label to prove to you that my introduction into the field of law is because of my passion for understanding the constitution, constitutional rights, people, and the role of the government and the role of the judiciary. This is what made me not only feel comfortable with law, compassionate with law, and develop passion for law. So, if you look at the schooling I had done with Nani to Sirwai to Fali to Ram, this kind of familiarity with people of the highest attainment in the field of law and jurisprudence, not many people would have got, but for the fact that I was associated with the Indian Express, and through Indian Express, I was fighting for this great cause, which proved to be the best years of my life. Achut Patwardhan once told me, I don't know how many of you heard the name, he was the man who led the 1942 Quit India movement. He told me once, whatever you achieve in life, Guru, the years that you spent with the Indian Express will be the best year in your life. That is how it proved to be, because that expanded not only my vision, my knowledge, my understanding, and I was an Ekalavya of all these people, and that is how I am standing before you. Now, I'll tell you how I was encouraged. In a very important criminal case from Calcutta, I wrote a 90-page complaint charging with fraud, forgery, and all that. Ram told me, Guru, in my life, I have never come across a 90-page complaint. I said, Ram, I am applying the principles of conspiracy under the Calcutta rules for civil suit for this criminal case, because either we win the criminal case at the opening or lose it forever. He said, okay, I go by your assessment. And that case was approved by the High Court. The magistrate issued, you know it, what the case is. I don't want to mention the name of the case. So the process was issued, and the High Court, there was a bitter battle between Ram Jethmalani and Shanti Bhushan. Shanti Bhushan said the that the complaint is 90 pages it means that there is nothing in the complaint. That is why the weight of the complaint is now going to decide the fate of the case, or the quality of the content in it. So finally, we won before the High Court. Ram was in London. I rang up Ram and told him, you know how nice he was? Guru, my judgment was wrong. This 90-page complaint won the case for us. Can you find any other great mind encouraging a small man like me and enhancing my level of confidence? This is how I became familiar with law and comfortable with law. And now coming to the issue that has been debated so far, the idea of basic features or basic structure of the Constitution. I will again take you to an anecdotal reference with Mr. Sirwai, H.M. Sirwai. In 1980s in the Indian Express had carried on a campaign against Antule. And Antule and Dattasaman joined together and they shut down the Express. And if Antule, who was the chief minister, and Dattasaman, who was a person of physical means of handling, the people were not willing to come to the office. Journalists were afraid. Even the guards were afraid of coming to the office. So in that situation, we decided to file a writ petition. And then we decided to close down the paper. And the government refused to give permission under Section 28O of the Industrial Disputes Act. So we filed a writ petition where we said that there are reasonable restrictions for the right to freedom of expression, but for the right to silence, there is no restriction. Right to silence is absolute under the Constitution. This is what Sirwai was to argue. So when I went to brief him, he said, I know everything. You have said this in page 21, this in 29, this in 48, this in 62. The briefing was over in 2 minutes. So I told him, sir, I want to sit with you for some time. And you have closed the whole thing in 5 minutes. What do you want to ask? You can ask. Sir, can you tell me something about Golaknath case and Keshavananda case? I had Golaknath knocked out. I said, yes. Sir, I'm a student of law. I have read your constitution books. and I'm fairly familiar with how the constitutional amendments moved in 1971 onwards. Can I ask you a question? Sir, previously, the unamendability of the Constitution was limited to Part 3 of the Constitution. And that is what you fought against. That you cannot say fundamental rights cannot be amended. That was the case of the government. But you have ended up with a judgment which has extended the unamendability to the whole of the Constitution. He said, yes. This is an extreme reaction. Golaknath was a reaction. This is an extreme reaction to Golaknath. This is what we have to understand when we are talking about Keshavananda case. The political system and the judicial system, when they lose mutual trust, what happens? The political masters, the political sovereign always wants to control everything. The simple point I will mention to you, when Surya Prakash is here, he only brought it out. When the first amendment was proposed to Article 19(1)(a), the idea was Jawaharlal Nehru wanted the restrictions without the word reasonable. But all the people sat together and said, no, it's not correct. Even though you are Jawaharlal, we advise you that the restriction should be reasonable. So there was an internal mechanism in the political sovereign's mind which made the word reasonable restriction possible in the legislation. This was lost when Mrs. Gandhi came. You know what happened? Bank nationalization, and then Privy Purse case, and then the conflict between the judiciary and the executive started. And Keshavananda was one of the, Golaknath case was one of the principal drive of this. And it is true that it was a too tightly worded judgment for anyone to be comfortable with it, though it was a very well written judgment. Not that all judgments well written are good judgments. And so that went into the reaction. Now we do not know which part of the Constitution, and that Honorable Chief Justice Mr. Deepak Mishra listed the things which the constitutional makers did not see as the unamendable part of the Constitution. For example, it is now mentioned about the federal structure. Can India not think of tomorrow a presidential form of government? Let's assume the Constitution votes for the presidential form of government. Can the Supreme Court strike it down saying that it violates the rule of the basic structure of federal structure? You know, I think there is lack of balance. And my view is a dissenting view. Any dissenting view is an appeal to the future and brooding conscience of judiciary. This may appeal. So let us not think that the basic structure theory is so well founded. From a concrete position of unamendability of Part 3 of the Constitution, we have gone to an abstract position of unamendability of any part of the Constitution. And if the Supreme Court decides that this is the basic structure, who is to question it? For example, the NJAC case. It could well have been read down that you cannot override the two members of the judicial system. And we read it down. It's not possible. The matter would have been solved. But the question of reading it down would not have given the judiciary the position that it wants, namely that it wants independence from the government. That is also not correct. In fact, I had a discussion with the Reserve Bank Governor, Y.V. Reddy. He told me that we should be independent, but there is also some interdependence. That is how the system works. And I think that we are now 50 years after this judgment was pronounced. And there has been, as the Honorable Chief Justice said, that there has been enough empirical evidence to understand this. And I think my appeal is that the framers of the original Constitution had kept one thing in mind, that the fundamental rights of the people should not be affected, whatever is the system of governance. Now, the basic structure theory brings about a situation where the judiciary will decide the system of governance also. This is not the intention of the original framers of the Constitution. It may work for some time, but a very powerful sovereign coming. And powerful sovereign can be produced by democracy. It's not that powerful sovereign will be produced by any method other than democracy in India. Such a person may take a position. Again, a confrontation can come between the judiciary and the legislature. I think it would be within my rights as a citizen to appeal to the judicial fraternity and also the entire intellectual basis of judicial functioning, law, courts, that we should have a relook at the basic structure theory. And with that, I finally want to say only one thing. I have been seeing what's happening in the last 40 years. The state of the court, the state of the bar, the state of the media, the state of the discourse. Now Ram is not there. We see a dwarfing. All tall people, when they disappear, we don't see an equivalent person on the horizon. We need tall people, sun-crowned, and they cannot come. If they are going to discuss only about their fee structure for cases and the turnover that they achieve in a month or in a year, we have to move away from all. At least some people have to move away from all this. Tall people cannot be produced by mere money making. In fact, tall people are those who keep away from this. So we need to pray for, as the American senator did when the Watergate case was going on. He said we need tall people, sun-crowned, who live above the fog of, I forget the full poem, it's a beautiful poem. And with a drop in his eyes, he closed, saying that no system will work unless there are tall people. We have to produce tall people. Thank you very much.
Thank you very much, Mr. Gurmurthy. As always, pleasure hearing you. Our final keynote speaker this evening is a senior advocate and one of the foremost constitutional lawyers who's been part of milestone cases like decriminalizing homosexuality and the right to privacy as a fundamental right. He regularly argues on constitutional matters and has literally written the book on environmental law in India. Let's put our hands together for Shyam Devan.
Thank you very much for that. Minister, Chief Justice, members of Parliament, eminent jurists, journalists, members of the Jethmalani family, ladies and gentlemen. Let me as well begin with my tribute to the person whose memory we today mark. I'll share with you two early encounters. The first was when I was in class 8 in 1975, and my father suggested that I visit the Bombay High Court to hear Ram Jethmalani in a critical case for preserving our liberties. This was 1975, late 75. It was during the emergency, and the case was titled N.P. Nathwani versus the Commissioner of Police. It was my first visit to the Bombay High Court and to the Chief Justice's court. And the bench comprised Chief Justice Kantawala and Justice Tulsapurkar, who later on, of course, came to the Supreme Court of India. The judgment is reported in volume 78 of the Bombay Law Reporter at page 1, and it records the appearances N.A. Palkhiwala with R. Jethmalani, K.S. Cooper, A.B. Divan, S.J. Sorabji, and 153 other advocates as per the list handed over by Gagrat and Company. The Commissioner of Police had refused permission to a group of lawyers to hold a private meeting to discuss the preservation and promotion of civil liberties and the rule of law. The bench unanimously, there are two judgments, one by the Chief Justice, one by Justice Tulsapurkar, they preserved the ancient right of assembly and quashed the police commissioner's prohibitory order, which prevented the lawyers, or which had prevented the lawyers from convening the meeting. Ram's advocacy was stirring. If my math is correct, he was 52 at that time, but his presence and his powerful advocacy transformed the court into a theater. It was a mesmerizing experience for a schoolboy and an early lesson on the indispensable role of lawyers and judges in preserving liberty. The last paragraph of the law report sort of piqued my interest, so I'll read it to you. It goes this way. It says, Mr. Sorabji on behalf, and this is what Mr. Gurumurthy had also mentioned. Mr. Sorabji on behalf of the petitioners stated that counsel and attorneys appearing for the petitioners are not charging any fees and will be only pressing an order of costs restricted to the mere out-of-pocket expenses incurred, of which a statement is handed over. In view of this statement, the respondents are directed to pay the petitioners a sum of rupees 3,742 and 51 naya paise, being the out-of-pocket expenses incurred by the petitioners. So it was a small triumph at a very dark time in our history, no doubt made sweeter by the 3,742.51 rupees which the police commissioner was required to pay. My second early recollection, was in the year 1977. So we are 2 years on. And by then, Ram had left India. He'd left India in 76 during the emergency and had returned to contest the Lok Sabha elections. He ran against the serving law minister, H.R. Gokhale, in the Bombay Northwest constituency. And I remember attending a meeting at Marine Lines in Mumbai. There was a hall where the opposition candidates were all on the stage, but not Ram. Where was Ram Jethmalani? Midway through the meeting, there was a slight commotion, and in strode Ram to great cheers and applause. I remember him walking onto the stage, apologizing for being late. Went on to say that the Prime Minister's intelligence agencies had projected a very bleak prospect for her and that she was set to flee the country. That is why the Hun is on the run. These encounters distilled for me some of Ram Jethmalani's great qualities: courage, an unflinching focus on freedom, an actor's way with words, and fearlessness for the cause of the client. Let me move on now to basic structure. And frankly, I thought that by now, as the last speaker, this ground would have been covered. But let me just share with you a little nugget. The notion of basic structure, which has been explained by the speakers ahead of me, actually started with a German professor, Dieter Conrad. And he delivered a lecture at Banaras Hindu University where he propounded a theory that some things in the Constitution are immutable or are unchangeable. And barrister M.K. Nambiar, who argued Golaknath, found out about the Conrad lecture through his friend T.S. Ramarao, a law professor at the Madras University. So this is how it was run initially in Golaknath. And then, of course, Palkhiwala took it to a whole new level insofar as the Keshavananda Bharati case is concerned. Let me just indicate a couple of factors as I understand them in terms of context, because I think political context is very important to understand and justify the basic structure doctrine and why it's so important for us here in India. So it was mentioned that there was the popular government had pushed through and made efforts at a large number of laws which sought land reforms. Privy Purse was mentioned, bank nationalization, taking over of other land and and assets was mentioned, and therefore a clear attack, not just at part 3, which is fundamental rights, but also a constant testing of the bounds of judicial review. What can be done? How far can the courts go? How far should the courts go? And allied to this sort of, searching interrogation on the limits of law in terms of judicial review is another aspect of our constitutional model. And that really is what I think Mr. Nariman mentioned, that our constitution has been amended 105 times in 73 years. 105 times in 73 years. Now contrast that with the United States Constitution, which has been amended 27 times in 234 years. Or consider the Japanese Constitution, which hasn't been amended even once since 1946. In Australia, in 121 years, it has been amended just 8 times. So what you have is that, we have a great regard for our constitution. We have a great regard for constitutional sanction. And a result of that is that we have certain provisions which I suspect don't make their way into many other constitutions. For example, just ahead of a chapter which is, loftily titled Relations Between Union and States, very important, part 11 of the Constitution, or the Scheduled and Tribal Areas, which is part 10 of the Constitution, is a whole chapter in our Constitution beginning with Article 243ZH, and it is titled Cooperative Societies. Now, I can scarce imagine that there would be parts, that there'd be too many constitutions anywhere in the world which has cooperative societies right up there in your basic and foundational document. But we have it. And so there are several parts which, of course, can be removed, which can be amended, which can be altered. But then there are others, I suspect, part 3, for example, with some exceptions, which must hold out if we are to preserve our democracy. So Article 368, which was also referred to, is the great constitutional provision by which the Constitution itself comes to be amended from time to time. And here I'd like to borrow Nani Palkhiwala's phrase, deface and defile. And what he says is, and what he writes is, that does the constitutional amendment, the question or the test is, does the constitutional amendment deface and defile our great charter beyond recognition with respect to any of its essential traits? Palkhiwala ends his 1974 book, Our Constitution Defaced and Defiled, with a caution. The amending power under Article 368 is not a death wish or a provision for legal suicide. To quote him, the nation may pass through times like the present when it suffers a loss of identity, but never the Constitution. The founders had an unshakable faith that however stormy the days, the preservation of the identity of the Constitution will always enable the nation to come back into its own. And so the basic structure doctrine is really about protecting the essential identity of the Constitution. Very briefly, I think many of these doctrines in law are tested or are valid depending on their utility. I believe it's been of tremendous utility for us here in India in preserving crucial aspects of the Constitution, such as, for example, the scope of judicial review and the power of the court, or reserving to the court or our higher judiciary the power to strike down legislation which otherwise falls foul of constitutional provisions, and a few other areas also where the basic structure doctrine has been applied to preserve liberties, to ensure that our democracy remains intact and doesn't suffer too many inroads in terms of rule of law. And as Mr. Nariman mentioned, this doctrine has found resonance beyond our shores. So we have the doctrine applied to strike down constitutional amendments in Bangladesh, in Belize, as was mentioned by Mr. Nariman as well, where the 8th constitutional amendment of 2011 was struck down because it was found to make too much of an ingress in terms of destroying property rights. Kenya has used and employed the doctrine for striking down one of their constitutional bills. Uganda as well, Malaysia as well, after a little bit of back and forth, and Pakistan has adopted this particular doctrine. Singapore found that the basic structure doctrine is not really aligned to their constitutional form, their history, and so they rejected it. I had the advantage of access to a manuscript which my father maintained during the Keshavananda Bharati case. So as was told to you, there were 13, it was the biggest and strongest panel in our Supreme Court, 13 learned judges. Nani Palkhiwala was leading the charge on behalf of the petitioners. There was H.M. Sirvai, who was leading the defense of the constitutional amendments on behalf of the states. And this is what my father penned on Thursday, December the 21st, 1972, from his manuscript, 30th hearing, 3:40 p.m. Nani Palkhiwala. In another 20 minutes, I will have done. I will end as I began on the question of approach with a few well-chosen and well-phrased words of a distinguished lawyer. I would, however, request your lordships not to read the name of the author. Palkhiwala given cyclostyle bunch, which he hands over to the court master. I again request your lordships not to read the name, because if you do, you will not believe your eyes. The name is H.M. Sirvai. Laughter. 3 interruptions by Sirvai. Sirvai. Articles written, Member of Parliament in the Select Committee told me that certain clauses were dropped because of my articles. Nani Palkhiwala, thank you. Sirvai, I will fully explain the articles. Nani Palkhiwala, you will do so at length when your turn comes. Justice Hegde shows that judges and lawyers should not write articles. Justice Chandrachud, Y.V. Chandrachud, Mr. Palkhiwala, have you not committed a breach of copyright? Laughter. The punch in Palkhiwala's closing submissions is revealed on a reading of Sirvai's passionate defense of the right to property in a series of 3 articles that had appeared in the Times of India 17 years before Keshavananda Bharati was argued. So let me end with some words from Jethmalani, Ram Jethmalani, on Nani Palkhiwala. And when Palkhiwala passed in June 2004, this is what Mr. Jethmalani had to say. I believe that Nani's greatest contribution in the field of constitutional law was his glorious success in the Keshavananda Bharati case. Nani had realized that the constitution had been treated with even less respect than is due to the Cattle Trespass Act. He brought in his complete legal expertise and repertoire to sustain a unique proposition. Whatever be the width of the amending power of the Constitution, you cannot, by any kind of majority vote, alter or destroy its basic structure and framework. The government of the day made an inglorious attempt to have Keshavananda judgment reviewed and reversed. Fortunately, the judges did not accept the invitation. The doctrine is now an incontrovertible part of our constitutional jurisprudence, and India is spared the danger of demise of its democracy. The judgments of our court and the judgments of the overseas courts which have upheld basic structure use expressions like pillars, supports. These are the great supports and the pillars of our constitutional edifice. But to end, let us also remember that in addition to the pillars and the supports, we need spaces. We need spaces for our citizens. We need spaces for the citizenry speaking through civil society. We cannot possibly afford a situation where there is no space for a comedian, there is no space for a journalist, There's no space for a cartoonist. There's no space for an academic. So the defense of democracy, assured, at least for a while, by this important utilitarian principle of basic structure, also requires each one of us, like the very eminent lawyers mentioned in the past, to ensure that the spaces do not shrink any further. I thank you very much, and I thank Mahesh for this. Thank you.
Shyamji, many thanks to you. It's been a delightful evening. And as a last part of the proceedings, it's our proud privilege to announce to you something that is as larger than life, worth doing, and special as the legendary man it seeks to honor. The Sunday Guardian Foundation, in the memory of Ram Jethmalani on his birth centenary, has formulated the Will of Steel Awards. Under the auspices of these awards, we today confer the first inaugural Ram Jethmalani Prizes for Journalism. Honored dignitaries, ladies and gentlemen, the awards being conferred today now constitute the grandest purse-carrying award for journalism in the whole world. The main winner today will walk away with a check of 14 lakh rupees and a gold medal, a purse that is larger than the Pulitzer Prize. In this inaugural year, this has been open to journalists from India. It's aimed that next year it will be open to the best in the fourth estate from the entire world. We've been privileged of having an amazing jury who have deliberated and voted for the worthy winners. Let's unveil the jury names and the awards, please. Could I request Shri Mahesh Jethmalani and Shri Kartikeya Sharma, Member of Parliament, to kindly escort our guest of honor, Shri Arjun Ram Meghwal, Union Law Minister, to the front of the stage for the conferment of the first award, the Ram Jethmalani Prize for the Service of Humanity. Let's reveal the shortlist and the winner, please.
The Jethmalani Prize for Journalism in Service to Humanity, to be awarded for rare and noble contribution for the promotion of democracy, good governance in the spirit of Vasudhaiva Kutumbakam, one world, one family. The shortlisted nominations are Aditya Raj Kaur, Naveen Suri, Hemant Parekh, and Hira Azmat. The winner of the Will of Steel Awards, Jethmalani Prize for Journalism in Service to Humanity is Aditya Raj Kaur, Executive Editor, TV9 Network.
Let's keep the award going. Let's keep the applause going. Is the first one in what we hope is a series of many. Aditya, many congratulations. The next category of the awards, because of course we can't have an award ceremony with Ram Jethmalani name attached to it and not acknowledge legal journalism. Can we have the next category shortlist, please?
The Jethmalani Prize for Legal Journalism. For the most effective use of mass media to disseminate accurate information in public interest of legal proceedings, judgments, and legislations. The shortlisted nominations are Bar and Bench, Apurva Mandhani, Assistant Editor, The Print, Sadaf Modak, Principal Correspondent, The Evening Express. The Awards, the Jethmalani Prize for Legal Journalism is Bar and Bench.
Could I request Pallavi Saluja, Debian Roy, and Amir Khan to join us on the stage and receive the award, please? Many congratulations, Team Bar and Bench, Pallavi, Devian, and Amir. The third and final award conferment is the Jethmalani Prize for Empowerment. Can we have the shortlist and the winners, please?
The Jethmalani Prize for Empowerment for the most effective promotion of gender empowerment, social upliftment of tribals and marginalized groups. The shortlisted nominations are Hina Rothki, Deepan Vitanayogi, Ekta Kapoor, and Vishal Bharti. The winner of the Willow Steel Awards, the Jethmalani Prize for Empowerment, is Hina Rothki, Special Correspondent, Legal Express.
Hina ji, if you could join us on stage. And as we culminate this evening, Arjunji, Mr. Megwal, could I request you, sir, for both Mahesh ji and for Karthikeya ji, gentlemen, if you could stay with us, we have a special memento to carry away from this evening. Megwal ji, if you could present this first to Shri Mahesh Jethmalani. And the second one to Shri Karthikeya Sharma, who has been gracious enough to support the formulation through the Sunday Guardian Foundation. With that, I request Shri Karthikeya Sharma, Member of Parliament, to kindly give us the vote of thanks.
I would like to extend my gratitude to everyone on behalf of the Sunday Guardian Foundation for coming and celebrating the life and force that was Mr. Ram Jethmalani. Like many others here, I knew him personally and can say with authority that Ram was not only a leading legal luminary for decades, but he also influenced many communities from different fields. He was the chairman and the founder of our paper, The Sunday Guardian, and wrote extensively with unimaginable grit and conviction. I and my team conceptualized the idea for the Will of Steel Awards in journalism as Ram was an embodiment of it in every sense, and it would encourage journalists who work hard every day to get us news out there despite all odds. I would like to thank our chief guest, Honorable Chief Justice of India, D.Y. Chandrachudji, for taking out time for the event, our guest of honor, Honorable Law Minister Arjun Ram Meghwalji, for gracing us with your presence, sir. I would also like to thank our guest of honor, Attorney General of India, Shri R. Venkatramani for taking out time, our keynote speakers, Justice Deepak Mishra, Senior Advocate Fali Nariman, Shri S. Gurumurthy ji, and Senior Advocate Sham Devan for such a thought-provoking discussion which has left us with a lot to ponder on. I would also like to thank Mr. Mahesh Jethmalani for his support for this event and being patient in the entire planning and the execution of the event. I would like to thank the team and the teams who worked tirelessly for the execution of the event, And would also like to thank the esteemed jury led by Justice Bobry, who took out time to select the winners from the many entries that we received for the Wheel of Steel. I would like to congratulate the winners of the Wheel of Steel Awards and awards are a testament of your hard work, your desire to report and get stories out there despite the very many challenges that there are in the world today. Thank you very much. Thank you.
Thank you, Shri Kartikeya. And with that, ladies and gentlemen, we conclude the centenary Ram Jethmalani Memorial Lecture. Thank you for your time and for your patience, and to all our guests and dignitaries.